Please listen to the legal disclaimer at the end of this video.
Hi, this is Boiler from notlegaladvice.org, and I wanted to talk about three things today. I wanted to talk about what you do when you file a lawsuit and the opposing party answers. What do you do with that answer? I wanted to talk a little bit about settlements, and lastly I wanted to talk a little bit about prejudice and without prejudice when you are releasing a party from a lawsuit or what have you. I just kind of wanted to review that with you guys. It's on a lot of my documentation and a lot of my podcasts, but let's just go over it one more time because it seems like people ask a lot about it. So let's start talking about you've filed a lawsuit against somebody and they have, depending on the court rules, usually about 20 days to answer, and they answer. And what do you do with that answer? When I first started doing lawsuits, I was confused by some administrative processes. And what the administrative processes say is that everything that you don't rebut stands as the truth in the court. So it's a term called acquiesce. So you acquiesce to whatever they say if you don't rebut it. So that's generally not true, especially with an answer. So when you file a lawsuit and they answer, you don't need to do anything. You need to, if you're in the federal courts, you need to get ready for your 26F scheduling conference. That's the next step. So with the answer, no matter what it says, you shouldn't necessarily, unless it's just something really crazy, but just a normal answer, they're going to deny that they did everything that you said, and that's kind of standard. So you don't need to do anything. Just get ready for the scheduling conference. A 26F scheduling conference is the next step after they answer, and what that sets down is a schedule for how things are going to proceed with the case, how long you have to do discovery and things like that. So that's not a big deal either. I wanted to talk a little bit about settlements, and specifically I have a friend that I've been helping, and he got sued in county court, and he sued the people that are suing him in county court, he sued them back in federal court. So when he went to court for the county court, the lawyer agreed to drop the county court case, and my friend didn't read the settlement and just signed it, and the county court case went away. And then in the federal case, we decided let's keep going after him in the federal court, but we didn't realize that when he signed his settlement for the county court case, that he signed saying that all claims that he had to him prior to the date that the time and date that he signed that settlement or that release, he wasn't going to hold him accountable for anything that they'd done in the past, basically. So going into federal court, all they would have had to do is drop that document and that case would have got dismissed. So really read carefully anything that you sign, especially if you're in court, they hand you something to sign, ask for some time so that you can read it. Don't just flip through it and sign it. My friend really just wanted to get out of the county court case. That was the whole goal of filing in federal court, but he got what he wanted basically, but we really thought he could still go after him in federal court, and he couldn't because he didn't read the document. So the last thing I want to talk about is when you dismiss a case, you can dismiss it with prejudice or without prejudice, and I want to quickly review that. I probably should do that every couple months because people seem to get confused for some reason. But if you dismiss somebody with prejudice, that means that you can't go back after them. So say you're involved in a court case, you release them with prejudice, and then you decide to file another suit against them for the same thing. You're not able to do that. You can file it, but it'll get dismissed pretty quick, and you'll look like a clown in front of the court. Without prejudice means that you dismiss the case, but there still may be issues, and that you can still go after them for the same cause of actions. So if you dismiss somebody with prejudice for a FDCPA case, that doesn't mean that you can't sue them for TCPA. It just has to be something different. So that's all I really had to talk to you about today. My website is notlegaladvice.org, and I'm on Facebook under Boiler Not Legal Advice, I believe. If you go to my website, you'll be able to find me on Facebook. I do a lot of updates on there and just passing along the things that I see on the internet. So anyhow, have a great day. Thanks.
This is the legal disclaimer. While the information on this site deals with legal issues, it does not constitute legal advice. The materials in this video and related websites are provided for informational purposes only and do not constitute legal advice. We do not advise on the application of law to an individual's specific circumstances. Although we go to great lengths to make sure our information is accurate and useful, we recommend you consult a lawyer if you want professional assurance that our information and your interpretation of it is appropriate to your particular situation. There are no lawyers in this video or on the notlegaladvice.org family of websites. The contact information for this video is notlegaladvice.org, that is the main blog, nlapublishing.org, that is the main book site. The email address is boiler@notlegaladvice.org. If you have any questions or comments, feel free to email me. I'd love to hear from you.